Lesson: Sectoral privacy requirements in various industries. Understanding sectoral privacy requirements in various industries is crucial for professionals aiming to master the complexities of privacy regulations in the United States. The U.S. employs a sector-based approach to privacy, meaning different industries are subject to distinct sets of regulations. This approach can be challenging, but offers tailored protections that align with the unique needs of each sector. This lesson explores the core sectoral privacy laws, providing actionable insights, practical tools, and frameworks that professionals can implement to navigate and comply with these regulations effectively. The healthcare industry is governed primarily by the Health Insurance Portability and Accountability Act, which sets the standard for protecting sensitive patient data. HIPAA requires healthcare providers, insurers, and their business associates to implement safeguards to ensure the confidentiality, integrity, and availability of electronic protected health information. A practical tool for compliance is the HIPAA Security Rule Toolkit, which offers a step-by-step guide for conducting risk assessments and implementing necessary security measures. For example, a hospital could use this toolkit to identify vulnerabilities in its electronic records system, prioritize risks, and develop a mitigation plan to secure patient data. In the financial sector, the Gramm-Leach-Bliley Act mandates financial institutions to protect consumer financial information. The GLBA requires these institutions to establish a comprehensive privacy policy, disclose it to consumers, and limit the sharing of information with third parties. A practical framework here is the GLBA Privacy Rule Compliance Checklist, which helps institutions ensure they meet all regulatory requirements. For instance, a bank could use this checklist to verify that its privacy notices are clear and that consumer data sharing practices are appropriately limited. The Children's Online Privacy Protection Act addresses privacy concerns in the digital space, specifically protecting the personal information of children under 13. Online services that collect information from children must obtain verifiable parental consent and provide a clear privacy policy. The COPPA Safe Harbor program offers a practical tool for compliance where participating organizations can demonstrate their adherence to COPPA standards through self-regulation. For example, a mobile app targeting children could join a Safe Harbor program to validate its privacy practices, thereby gaining consumer trust and reducing regulatory risks. In the telecommunications industry, the Communications Act and its subsequent amendments, such as the Cable Communications Policy Act, impose privacy requirements on service providers. These regulations mandate the protection of customer proprietary network information and require consent before sharing it with third parties. A practical application involves using a CP&I compliance toolkit, which guides telecommunications companies in developing and implementing policies to safeguard CP&I. An internet service provider, for instance, can utilize this toolkit to train employees on CP&I handling procedures and establish robust access controls. The educational sector is regulated by the Family Educational Rights and Privacy Act, which protects the privacy of student education records. FERPA grants parents and eligible students rights regarding access to and the amendment of educational records, and it restricts the disclosure of these records without consent. The FERPA Compliance Toolkit provides educational institutions with a structured approach to ensure compliance, including guidelines for record keeping and disclosure limitations. A university can implement this toolkit to audit its data management practices, ensuring that student records are securely stored and only accessible to authorized personnel. A cross-sectoral perspective highlights the importance of data breach notification laws, which require organizations in various industries to notify affected individuals and authorities in the event of a data breach. These laws vary by state, but generally necessitate timely notification and specific content requirements for breach notices. A practical tool here is the Data Breach Response Plan template, which assists organizations in preparing for and responding to data breaches. By developing a response plan using this template, a company can ensure swift action to mitigate damage and maintain consumer trust following a breach. The complexity of sectoral privacy requirements necessitates continuous education and adaptation for privacy professionals. One effective strategy is adopting a privacy by design approach, which integrates privacy considerations into the development of products and services from the outset. By employing PBD principles, organizations can proactively address privacy risks, ensuring compliance and enhancing consumer confidence. For example, a tech company developing a new software application can embed privacy features such as data minimization and user consent mechanisms during the design phase, reducing the likelihood of privacy violations. Furthermore, privacy professionals should leverage industry-specific privacy impact assessments to identify and mitigate privacy risks associated with new projects or technologies. PIAs provide a systematic process for evaluating how personal information is collected, used, shared, and maintained. Conducting a PIA enables organizations to pinpoint potential privacy issues early and implement corrective measures. For instance, a healthcare provider launching a telemedicine service can conduct a PIA to ensure compliance with HIPAA regulations and address any privacy concerns before the service goes live. Case studies illustrate the consequences of non-compliance and the benefits of robust privacy practices. In 2013, Target Corporation experienced a massive data breach that exposed the payment card information of over 40 million customers. The breach resulted in significant financial losses and reputational damage for the company. This case underscores the importance of implementing comprehensive security measures and regularly updating them to address emerging threats. Conversely, Apple's commitment to user privacy, exemplified by its stringent encryption standards and transparency reports, has bolstered consumer trust and set a benchmark for privacy practices in the tech industry. Statistical evidence further reinforces the significance of sectoral privacy requirements. According to a study by the Ponemon Institute, the average total cost of a data breach in the U.S. reached $8.64 million in 2020, with healthcare being the most affected industry. These statistics highlight the financial impact of data breaches and the critical need for robust privacy protections. In conclusion, sectoral privacy requirements in various industries present both challenges and opportunities for privacy professionals. By understanding and implementing industry-specific regulations, leveraging practical tools and frameworks, and adopting proactive privacy strategies, organizations can enhance their compliance efforts and safeguard consumer trust. Continuous education, collaboration, and adaptation are essential for navigating the evolving privacy landscape and ensuring long-term success.